Good morning, everyone. Thanks for joining us this morning. Another beautiful morning here in West Michigan as we continue to explore how COVID-19 is affecting our society and our businesses and some of the measures that we can do to combat that. Today we're going to continue to discuss the Paycheck Protection Program. And this slide here is going to be focusing on forgiveness on the Paycheck Protection Program and really what we know to date. Similar to all of our webinars, this information is for informational purposes only, and we strongly encourage everyone to reach out if they have any further questions or comments or any other issues that they may have or any other questions. As we often do before we jump into the slides, we like to give a brief update on where we're at as far as COVID-19 relates to our world. As of yesterday, the worldwide count included 3.19 million confirmed cases, 227,000 deaths. In the U.S., we have 1.06 million cases confirmed, 61,470 deaths. Here in Michigan, we have 40,400 cases confirmed, 3,670 deaths. In Kent County, we have 1,395 cases confirmed and 33 deaths. So those numbers continue to rise, although we are seeing some changes in the trends of new cases and deaths across the world from county to county, state to state. There is some promising news of coronavirus-related treatments to be hoping that they increase the speed at which people recover from the virus, but none of that is concrete or available to the public yet, so it's all still experimental. The Federal Chairman Jerome Powell predicted that the economic data for the second quarter here in the U.S. will be worse than any data that we've ever seen for our economy. So still darkness ahead of us, but hopefully in the near future we'll get some positive news and start to see signs of a recovery. As far as reopening, Germany has taken some substantial steps to reopen their economy, resulting in an increase in the rate of infections, causing a call for a second round of social distancing and self-isolation. Likely the case that when we can really start to make efforts to reopen here in the U.S., we'll likely experience a similar trend and increase in uptick in new cases and deaths. And the process of reopening our economy will probably occur in waves as we open certain segments and close them and reopen them until a point where hopefully this all goes away for good. So jumping into the topic for today, by now everyone's familiar with CARES Act. Recently was provided some additional funding. So to date, there's been $725 billion committed to the PPP and other small business-related loans and programs. We've received guidance and information on a variety of topics related to the PPP. But to date, the one area that we're still waiting on substantial guidance and clarification on is how the program will operate with regards to forgiveness of loans. We had hoped to receive some guidance by now. So far, we've received limited guidance. We'll continue to monitor the situation. As soon as we hear or see anything, we'll obviously make sure to keep everyone updated. But for now, as we wait, we wanted to take an opportunity to kind of run through what we know so far, how we interpret the existing statutes and regulations in an effort to kind of begin the process of planning and calculating loan forgiveness and preparing for that process once we're actually dealing with it. So again, I do want to stress that we're still waiting on a fair amount of guidance on a lot of issues related to forgiveness, and what we hope to provide today is just a conservative interpretation of the existing statute and guidance and regulations that has been promulgated so far. All of that obviously is likely subject to change to the extent we receive any additional information, and we'll do what we can to continue to update everyone as things continue to evolve. So with that, let's go ahead and jump into it. The first real issue that one needs to consider with regards to ensuring forgiveness of their loans is making sure that the use of the loan is used for permitted purposes. So let's revisit that briefly. The loan can be used for payroll costs, group health care benefits, insurance, employee salaries, compensation, interest on all debt, including mortgage interest and non-mortgage interest, and rent and utilities. An important point to note here with regards to permitted uses is the fact that at least 75% of the loan must be used for payroll costs. With regards to with regards to utilities, we've generally seen that interpreted as including phone, internet, gas, water, electric, transportation, things like that. And again, just want to stress the fact that any funds used on used for non-permitted purposes will not be eligible for forgiveness. So that's the first threshold that one needs to consider when calculating forgivability. So from there's a subset of permitted uses, which is forgivable uses, which is essentially you have an 8-week period after receipt of the funds from the loan to use it for permitted forgivable uses, that 8-week period being commonly known as the covered period. The permitted uses and the permitted uses for forgivable purposes are very similar. Certain caveats, certain nuances include the fact that with regards to interest on debt, only funds used on mortgage interest is forgivable. So interest on other forms of debt is not forgivable. And again, we want to stress with regards to cash compensation, the fact that employees' compensation is only considered up to $100,000 prorated during the covered period. So both for purposes of determining the amount that can be borrowed and for purposes of determining the amount that can be forgiven, funds used up to $100,000 per individual in the form of cash compensation will be considered. So that doesn't mean that you cannot use the funds for cash compensation in excess of that $100,000, but any amounts used for those purposes will not be considered eligible for forgiveness. So what exactly does that look like? Let's just run through some numbers to make sure that we understand how that works. Just a sample fact pattern here. If a borrower applies for the loan on the 6th of April, receives funds on the 13th, and they anticipate expenses in the amount of $50,000 for payroll expenses, first due and payable on the 17th of April, and then every 2 weeks thereafter, so biweekly payroll period. Rent in the amount of $10,000 due on the 1st of each month, and utilities in the amount of $1,000 due on the 1st of each month. Dissect that a little bit. So again, we want to stress the fact that the covered period is the 8-week period following receipt of the funds. So although the application was made on the 6th, for purposes of determining eligibility, you would consider the period between April 13th and June 8th, the 8-week period following receipt of the funds. And then how does that all factor into determining the amount that's potential for forgiveness? You would have, in that specific case, potential forgivable amount of $222,000. This is broken down in payroll expenses of $200,000. Again, it was $50,000 first due and payable on the 17th, and every 2 weeks thereafter. Within the covered period, that would give you 4 pay periods. the first being on the 17th, then on the 1st, then on the 15th, and then on the 29th, totaling in $200,000 in payroll expenses. Total rent expense of $20,000, $10,000 each due on the 1st of each month. That would include the 1st of May, the 1st of June, and similarly, utilities expense of $2,000 due on the 1st and the 2nd of June. So one of the biggest questions that a lot of folks have about calculating the potential forgiveness amount is how it relates to how do you calculate expenses that are incurred before the covered period, expenses that are incurred after the covered period. How does actual payment of those expenses play into the calculation of the potential forgiveness amount? And again, this is an area that is we're still waiting on further guidance on, but generally we interpret it and we advise people to basically be consistent with their past practices. And to the extent you're consistent with your past practices, the amounts used will be eligible for forgiveness. So what that means is, even if the timing of payroll doesn't exactly line up with the timing of the covered period, you would continue to pay payroll as you have historically done so. We wouldn't necessarily, to the extent that you have a pay period that's due after the 8-week period, we wouldn't encourage you to accelerate that payment and go ahead and pay, prepay those payroll expenses. To the extent you have insurance, rent, and other potential eligible expenses, we wouldn't encourage you to prepay any of those expenses. And vice versa, to the extent that you had an expense that was incurred before the pay period, it's unclear whether one could use funds for those types of expenses. But, again, we would encourage you to just continue to be consistent with your past practices. So amounts used for example, past due rent, past due mortgage, interest expense, things like that, would not be eligible for purposes of determining the potential forgivable amount. So just kind of getting into the nuances there, that first payment, there are question marks about whether that first payment, if it's attributable to work done prior to the loans being received, prior to the covered period beginning, is that first payment eligible for forgiveness? Is it partially eligible for forgiveness? To the extent that it's paid during the covered period, consistent with past practices, we would say it's fully covered. And for any period, for any payroll expense, again, that's due after the covered period expires, that to the extent that it's attributable to work done during the covered period, we would not interpret that as being potential funds, potential payroll that can be used for determining your total potential forgivable amount. So once you determine the potential forgivable amount, that amount is then adjusted by two things. The first thing that it's adjusted by is the extent to which your full-time equivalent changes or is reduced. And the way that this works here is to the extent that the borrower's full-time equivalent or FTE during the covered period decreases compared to the borrower's average number of monthly full-time equivalent employees during one of two periods, either the period beginning on February 15th, 2019 through June 30th, 2019, or the 2019 period, or you would compare it to the period beginning on January 1, 2020 through February 29th, 2020, the 2020 period. And so the way it would work is you would first calculate your full-time equivalent during the covered period. You would then calculate your full-time period either during the 2019 or the 2020 period. You would obviously select the period that had the lower full-time equivalent. And then you would compare those two periods. So to the extent that there is a reduction in your full-time equivalent, you would experience a proportionate reduction in the potential forgivable amount. Now, a nuance here is for any reduction in your full-time equivalent that occurs between February 15th and April 26th, the borrower would be eligible to remedy that reduction to the extent that they restore their full-time equivalent by June 30th. Let's just take a look at some numbers and see how that works. So here, if we have sample fact pattern where the borrower's full-time equivalent during the covered period is, say, 95, your head count's 95 full-time equivalent employees. Let's assume that there were 3 employees that were terminated on the 1st of April and 2 employees that were terminated on May 1st. So the first set of employees would fall within that category of employees that you can restore that are eligible for receiving a credit, and that second category of employees that falls outside of that window of restoration would not be eligible for the credit. Again, assuming that the borrower's full-time equivalent during the 2020 period is 105, and the borrower's full-time equivalent during the 2019 period is 100, you would select the lower 2 numbers. And so you would have a reduction in your workforce of 5%. However, again, to the extent that you experience a reduction in your workforce during the eligible period, and you restore your full-time equivalent by June 30th, you would get a credit for the individuals that were for the reduction that you experienced during that covered period, between June 15th, 2020 and April 26th, 2020. So in this case, 3 employees were terminated during that period. If you borrower rehires or brings back 5 full-time equivalent employees, it doesn't necessarily have to be those same individuals. But to the extent you bring back certain individuals to restore your full-time equivalent back to what it was prior to the covered period, you would receive a credit for those individuals. And so in this case, the reduction amount to the potential forgivable amount would be 2%. You would get a credit for the 3 individuals that were terminated on April 1st. And so your full-time equivalent during the covered period would be 98. We compare that to the base period being 100, and that's a 2% reduction, and then you would experience a proportionate 2% reduction in the amount of potentially forgiven loans. Now, a couple of common questions here is, how does one calculate their full-time equivalent? This is also something that we're awaiting further guidance on, but we generally view it as being calculated basically by the individual borrowers on what they have historically used to calculate their full-time employees. And so we've seen some individuals and some individual borrowers using a per-hour basis of 30 hours a week to determine their full-time equivalent, others using 40 hours a week. And so long as you're consistent with your approach, for now at least, based on the lack of guidance, we think that your consistent approach would be fair and permitted for purposes of determining one's full-time equivalent. Other questions that arise with regards to restoring one's full-time equivalent for purposes of receiving the credit is to what extent, how long must those individuals be employed or be rehired for purposes of receiving the credit, and how long must they remain hired following that June 30th deadline in order to receive the credit? And most of those questions right now have not been answered. As far as we know, so long as you have restored your full-time equivalent by that date, even if it's on that date, then you would be eligible to receive that credit. It's unclear as to whether those individuals must be on board for a week, 2 weeks, et cetera, prior to that date, or they must remain on board for similarly a week, 2 weeks, or whatever the case may be following that date. And then another question that arises with regards to calculating one's full-time equivalent and how the credit works is to what extent does a potential borrower have to fully restore their full-time equivalent? So in other words, if you experience a reduction in your full-time equivalent by, say 1 or 2 employees, let's say 5 employees, and you bring back only 3, are you eligible for a partial reduction in your full-time equivalent, or do you have to completely restore your full-time equivalent to receive the benefit of the credit? It's unclear at this point how exactly that works. In my example, this particular borrower restored their full-time equivalent. They restored their full-time equivalent by that June 30th date and only received a 3-person credit because only 3 individuals were terminated between the time period that's eligible for the credit. But to the extent an individual partially restores their full-time equivalent, it's also our belief that they would potentially receive a partial reduction and receive the benefit of the credit to the extent that they've restored their workforce. And then the next component of adjusting one's potential forgivable amount is reductions in compensation, reductions in salaries and wages. And so essentially, loan forgiveness will be reduced to the extent that salary or wages are reduced per employee in excess of 25% compared to those same salary and wages during the most recent full quarter. Nuance here is that, again, to the extent an individual receives compensation in excess of $100,000 on a prorated basis, any adjustment in excess of $100,000 would not factor into this calculation. And again, I want to stress the fact that this is only applicable for reductions in excess of 25%. So to the extent you experience a reduction in your compensation of 10, 15, 20%, those are permitted reductions and will not you will not experience a reduction in your potential forgivable amount in those cases. Similar to the reduction in the full-time equivalent calculation, to the extent that you restore your employee compensation by June 30th, you would receive a credit or an add back or any reduction in your compensation done between February 15th and April 26th of 2020. So how does that play out with actual numbers? So looking at our sample fact pattern here, assuming that the borrower's biweekly employee compensation during the most recent full-time quarter was $70,000. Again, the borrower's biweekly compensation during the covered period is $50,000. In this case, we would have a reduction of approximately 28.6%. And then if we assume that the borrower does not make any changes to their compensation by June 30th, so it continues to remain biweekly payroll compensation, biweekly wage and employee compensation of $50,000. What then is the total reduction? In that case, the total reduction would be $10,000, $2,500 per pay period. And so the way that this would work is, first of all, we want to stress that you want to calculate this on an individual basis due to the fact that reductions in compensation for employees that receive in excess of $100,000 are not factored in or not considered for purposes of this calculation. You want to look at each individual employee's compensation up to $100,000 and factor both their compensation during the covered period and the most recent full quarter. And then you would aggregate each individual employee's compensation during both of those periods to determine both the full aggregate employee compensation during the covered period and during the period, the quarter, full quarter immediately preceding the covered period. This allows you to get both an apples to apples comparison of those two time periods, and it appropriately factors in the fact that any reductions or any compensation in excess of $100,000 doesn't really play into calculation of how reductions in compensation can reduce one's forgivable amount. The example that I proposed here, we were assuming that there were no employees that receive compensation in excess of 100,000. But to the extent that there are employees that do receive compensation in excess of 100,000, and again, we're talking about wages and salaries here, cash compensation, you would factor in those employees' compensations only up to 100,000, and any compensation in excess of that 100,000 not be attributed to this calculation. In this case, there was a total reduction of 28%. Again, 25% reductions up to 25% are permissible. So you would only factor in the reduction in excess of that 25%, essentially approximately 3.6% of the total reduction, and then you would experience a dollar for dollar reduction in your potential forgivable amount. So it's a pretty straightforward calculation here. Any compensation reduction in excess of that 25% would just factor in to the reduction of your potential forgivable amount on a dollar for dollar basis. And those are really the three factors that go into determining forgiveness. First, the potential forgivable amount, which is the amount of permitted forgivable uses during the covered period, and then adjusting for reductions in your full-time equivalent and reductions in your compensation, your wages, and your salaries in excess of below 100,000, and reductions in excess of 25%. Once you calculate those factors, and then process for receiving forgiveness, the details are still waiting on clear details and guidance on how that'll work. But generally, the borrower would make the request to the bank that serviced the loan. You would have to submit documentation and verify the accuracy of the documentation, verifying the various factors that are considered for determining the forgivable amount and the adjustments to the forgivable amount, the documentation evidencing your full-time equivalent, pay rates, as well as the other factors that go into potential forgivable amounts. So you would want to submit documentation relating to mortgage, rent, utilities, etc. Once you submit the documentation, you would then have to wait at a maximum of 60 days. The lender must make a decision on forgiveness within 60 days of submitting the documentation. So with that being said, some practical advice that borrowers should consider, to the extent possible, aligning the covered period with the beginning of their pay periods. As I mentioned, we're still waiting on guidance as to what exactly it means for expenses to be incurred and paid. But to the extent that you can align your pay periods with the covered period so as to maximize the amount of pay periods within that covered period, that would in turn maximize the amount of funds that you could use for potential forgiveness. To the extent that you can create and maintain a separate bank account for proceeds for the loan to be able to establish where the proceeds, where and how the proceeds were used, would be greatly beneficial. To the extent that you have a related party rent, we encourage people to not make any changes to the related party rent. We've not seen anything so far that would state that related party rent or really related party transactions in any way, so salaries and compensation to owners, etc. All of that would be permissible uses and eligible for forgiveness. But the one piece of advice that we do advise is to avoid increasing related party rent and keep that as it is to the extent that it is market value. You can, however, increase compensation, issue bonuses, things like that, up to, again, that $100,000 threshold. So although we discourage you from changing or increasing market rent on related party leases, we do think it is permissible to increase compensation so long as it's within that $100,000 cap. Good record keeping and bookkeeping is going to be critical for obtaining forgiveness of the loans. We anticipate that a lot of the grunt work and a lot of the oversight will be done on the back end of the loan. And so in particular, to my last point here, loans in excess of $2 million, we encourage borrowers to be audit ready and make sure that they have all their ducks in a row, all the documentation to establish the various criteria of the PPP loan program, so eligibility, need for the loans, calculation of the loan amount, and then ultimately documentation ready to establish that the proceeds for the loan were used for permitted forgivable purposes in the appropriate amounts and in the appropriate ways. So with that, that's really the end of our production here. I do want to get into some questions that we received to try to help clarify any outstanding issues. To the extent I don't get to anyone's questions or don't address anything that may have come up during the presentation, the webinar here, please don't hesitate to reach out at any point in time to schedule a one-on-one talk and see if we can clarify any outstanding issues. So just jumping into some of the questions that were submitted. One question here is, are there any differences in the PPP rules as they relate to for-profit versus nonprofit businesses? Generally, no. There is some uncertainty about whether nonprofits can qualify as eligible business based on the alternative standard tests. So that's really an eligibility issue, but once it's determined that one is eligible, the rules for both profit and nonprofit businesses apply the same. Another question here is, can a worker obtained from a temp agency be used to reinstate employee headcount for your full-time equivalent? And it's unclear at this point. We haven't received guidance on that particular issue, but we do understand that temp employees count towards your eligibility, but they do not count towards your potential payroll costs to the extent that the temp employee is not one of your W-2 workers. And so if the temp employee is W-2'd by the temp agency, that would be their employee, and that would be that person, and their compensation would be eligible for the temp agency's determination of payroll costs and forgivable amounts and full-time equivalent, but not for the individual borrower's full-time equivalent. Some questions about utilities. Again, want to stress that includes phone, internet, gas, water, electric, transportation, and things like that. One question here is, do we have a worksheet or something that people can use to help guide them through the calculation of the forgivable amount and the adjustments? No, we don't have a worksheet. Our hope is that the presentation helped kind of run through some of the concepts with you. To the extent you have any questions, let us know. As far as actually receiving some sort of spreadsheet or anything like that, we would encourage you to reach out to your bank, as they're going to be the ones that ultimately make the determination on forgiveness. And so to the extent that they have any resources or documentations that they're familiar with or that they use, we would encourage you to use these same documents and the same spreadsheets. There's a question here about whether an employer has to pay wages to laid off employees in order to qualify for forgiveness. So really, by definition, if you're paying wages, then a person is an employee and they're not laid off. So to the extent that someone has been laid off, you would not be incurring any actual payroll expense for that individual. It's important to note, though, that, again, reductions in your full-time equivalent may adversely adjust your potential forgivable amount, but to the extent that you restore your full-time equivalent by June 30th, you would get potential credit for that individual, depending on when that individual was laid off or released. Question here, we received our PPP loan. Should we call back the laid off employees and increase the hours that we cut? So practically speaking, this is really a business issue that you would have to evaluate based on how you perceive the market will be when you bring back those individuals. But for purposes of the PPP and calculating forgivable amount, to the extent that you bring individuals back, that allows you to incur payroll expenses that will then be permitted for forgiveness, and that will also allow you to restore your full-time equivalent, which will allow you to retain your full forgivable amount and not experience a reduction in your forgivable amount as a result of a reduction in your full-time equivalent. So keep those concepts in mind when evaluating more of the business implications and the market implications of when it's wise to get everyone back on board and rev up operations. Question here, what happens if someone voluntarily separates during the 8-week period? Again, we're not exactly clear on this point, but our read of the act suggests that to the extent that the employer experiences a reduction in their full-time equivalent, the employer would be on the hook regardless of how that reduction occurred. So if someone were to leave or refuse to come in, someone were to quit, then it would be incumbent on the employer in that case to seek out and restore their full-time equivalent. Question here, what happens if you terminate an employee before the 8 weeks have passed? Will we have to pay a percentage back? And so it really depends on, so it's a comparison of your full-time equivalent during the covered period versus the base period. So to the extent that, there isn't a reduction in your full-time equivalent, in other words, to the extent your full-time equivalent during your covered period is equivalent to your full-time equivalent during the base period, either the 2020 or the 2019 period, you wouldn't experience any adverse consequences in that case. But to the extent that there is a reduction when you compare those two periods, you would, in that case, experience an adverse or reduction in your potential forgivable amount to the extent that you do not or are simply unable to restore your full-time equivalent by June 30th. Question here about whether the 8 weeks will be cash or accrued counting. Again, this is one of the biggest issues that we're just unsure about how the SBA will apply what the language refers to as incurred and paid expenses. We would at this point just encourage everyone to continue consistent with their historical practices of paying the various eligible permitted expenses. And to the extent we hear anything otherwise or any further guidance, we'll make sure to keep everyone updated. A question here about which employer payroll taxes will be forgiven. Only state and local, not federal. I have a question here where the person outlines what basically is a reduction in compensation that these individual employees are compensated almost on a commission basis, just based on the amount of work that they do, and to the extent that their operations have been reduced and they subsequently experience a reduction in the compensation paid to those individuals, will they experience any adverse consequences based on that pay structure, that commission type pay structure? And the answer is yes. So to the extent that you use the same formula to calculate compensation and to the extent there is a reduction in compensation, you would experience a subsequent adverse or reduction in your potential forgivable amount. But again, we do want to stress here that you are permitted to the extent that you use the payroll expenses, to the extent that you don't increase someone's compensation beyond $100,000, you are permitted to issue bonuses and otherwise increase compensation for employees, regardless of whether those employees are partial shareholders or partial equity holders. Want to again stress the importance of retaining for any related party leases, not changing in that case, not changing any the rent on any related party leases to the extent that the rent is fairly market rate rent. To the extent that it is above market rate, you may want to reduce your rent, but otherwise, you would want to keep that the same, but compensation can be increased. I understand the total wages. The question here is, I understand that total wages, the way that total wages are calculated for employees in excess of $100,000, but I want to confirm that this is only cash compensation. Correct. This is only cash compensation. With regards to the $100,000 cap, any forms of compensation that is not cash is not attributed to this calculation. And then similar question, will the, for purposes of permitted forgivable uses, will the PPP loan only cover the proportionate amount of salary up to $100,000, or will it cover wages and compensation regardless? And the answer is no, it really only covers compensation up to $100,000 prorated on a prorated basis. So that is just a few questions that we have here. Again, I want to stress that if anyone has any other questions or anything that's they're unclear about, feel free to reach out at any time, and we'd be happy to sit down and kind of work through any outstanding issues with anyone. Thanks again, everyone, for joining us this morning, and thanks for taking the time.